So I am Britt Burner, as Liz said, and glad you can be here today to discuss advanced directives with us. This is a topic that I think is really important for everyone over the age of 18. We never know when we are going to be in a position where we are unconscious or under anesthesia or have some kind of lack of capacity that's going to lead to others having to make decisions on our behalf. And having these advance directives signed, and that are documents in advance of needing them, we sign them, empowering others to make decisions and informing those other people what type of decisions we would want them to make, because they are our substitute decision maker. They are stepping in our shoes and making decisions where we can't make them. I've often talked about the first time that I signed a healthcare proxy was when I was probably around 30 years old, and I was having my appendix removed and I was being rolled into surgery, and I had this panic moment that I didn't have a healthcare proxy. And if I was under anesthesia and a decision had to be made, I wanted it to be very clear who would make that decision for me. And so I stopped everything and I asked them to give me a healthcare proxy, and I did sign one right there in the hospital. Of course, being 30 years old, they were certain I was a lawyer, so they were right, because most 30-year-olds wouldn't have thought of that. But it really is necessary for everyone over 18. And so a lot of people may have their children that are home for the summer from college and they're going to go back to school. And if something should happen, the parent, I had a parent who came in and said, they let me pay the tuition, they let me pay the books, they let me pay everything else. But if my child is sick or has to go to the hospital and they can't make a decision, I have no right to have medical information or really at the infirmary get that information. And so a lot of times we like to sign these documents to allow others to act on our behalf. So that's who should have it. Everyone over the age of 18. These documents do not expire unless you put a date by which they expire. So your healthcare proxy is a document, for example, that says who makes medical decisions for you if you are unable to make them for yourself. So you can name one person at a time. You do not name multiple agents to act concurrently, but you will name one person at a time. The document usually states that person's address and phone numbers. We obviously like to put cell phones so they could be reached in an emergency situation. And it is witnessed by two individuals over the age of 18 that are not those listed in the document. So in my situation that I was describing, I had the nurse that was assisting me, and it was very late at night. So there was somebody who was actually, mopping up the floors in a janitor's position who was the second witness on my healthcare proxy. And I signed that document. I stated who would make that decision. Now, I could have put on that document that the duration was 1 week, for example, or a year, or whatever time frame I wanted. But most often we put that healthcare proxies are for an unlimited duration. So again, it is not going to expire. But a lot of times people say, well, I signed a healthcare proxy, I think, when I was in the hospital, but I don't have it. I never took a copy. They put it in my file, etc. So you want to make sure that you actually have it, that it can be presented when you need it. A copy is just as good as an original. So if you make a healthcare proxy, you sign it, you have your two witnesses, you'll then make multiple copies and you can give it to your doctors. If you have to check into the hospital for some reason, you can present that. Some people, if they're particularly concerned that something's going to happen in their home, and if 911 has to be called and emergency medical services has to come, they've actually been trained to look on the back of the front door and on the refrigerator. So some people keep their healthcare proxy in one of those two places so that it can be readily available. And while the EMTs are not required to look at it and do anything with it, they will take it and it will go to the hospital where your agent can be notified if that becomes necessary. An important thing to point out about the healthcare proxy is it is only in effect if you are deemed incapacitated by a doctor. So this is precisely why the ambulance driver or the EMTs, the emergency medical services, are not required by law to follow that document, because at that point when they are called, technically you have not been deemed incapacitated by a doctor. Even though you might not be responsive, they are not required to follow that. The idea being that they are emergency services. They're there to transport you safely to the doctors and the nurses, and to the hospital, to the emergency room, where there can be a proper look at the document and make sure there aren't any issues. And so the EMTs will not be honoring a healthcare proxy in most circumstances. They will just be taking it and bringing it with the individual to the hospital. But we often have times where a family member calls us and says, well, my mom went to the doctor and I called and I said, on the healthcare proxy, I want information. And the doctor's office said, well, we can't give you that information because your mom's not incapacitated. And the doctor's office is correct in that situation. Until that person is deemed incapacitated by a doctor, the healthcare proxy document is not in effect. So it's a very important thing to realize. You don't need a lawyer to sign a healthcare proxy. Again, as I said in my story, I signed it in the hospital with 2 witnesses over the age of 18. If you actually look online, you can find on the Department of Health, New York State Department of Health website, they have a healthcare proxy with instructions on how to complete it. You want to be careful because there's a category on that form document that talks about whether or not your agent has the right to make decisions regarding artificial nutrition, hydration, end-of-life measures. And a lot of people don't realize that it says if you want your agent to be able to make those types of decisions for you, that you actually have to state that on the document. And so a lot of people ignore that section. They put in the name of the person, the name of the successor, the contact information, but they don't go as far as to state that the agent has those rights. And so you want to make sure that you're filling out the section saying that your agent knows your wishes regarding artificial nutrition and hydration, and that you want them to be able to make those end of life or extreme measure decisions. Now, it's not enough to just put on the document that they know that. It's important to have those conversations. So if you have someone who's going to step in your shoes, talk to your doctors, weigh the pros and cons of a treatment decision, and then make that decision, you would want that individual to know or to have somewhat of an idea of how you feel about these kinds of measures, so that when they're making that decision, they're not doing it for themselves, they're doing it as your substitute. They're doing so with the knowledge, however extensive you want to give to them, of the kinds of decisions that you would choose for yourself in certain circumstances. So these often are not a one-time conversation. That these types of conversations are often things that come up over time. Maybe something in the news or a family situation or a friend of the family or a story comes up about someone going through a specific medical incident, and maybe it triggers a conversation between the individual and the agent that they're naming. If this were me, this is what I think I would want. It's just doing your agent a favor because you're making their job a little easier on them, giving them ideas. It's also better for you because you're arming your agent with the information to do what you think you would do in those cases. We all have heard back in the 90s about Terry Schiavo, the woman down in Florida, and she didn't have these documents, and there was a question as to her healthcare decisions, and it was an argument between her parents and her husband. And documents like this, even for young people, can often be really helpful when they're not often having these conversations. They're at least saying who they would want to make those decisions for them. Along with the healthcare proxy, people often will sign a living will. A living will is another advanced directive, and it does not name an individual, but it says that whomever your decision maker will be, that if you are in an irreversible state with no reasonable expectation of recovery, that you would not want certain artificial means or certain treatments. You would want those treatments withheld or withdrawn. And those treatments can include cardiopulmonary resuscitation. It can include kidney dialysis. It can include antibiotics, and the list goes on, cancer treatments. And so there's certain people who say, well, but I would want dialysis if I needed it. But at a certain point, there's a decision that's often made whether or not someone should continue on kidney dialysis or not. And what you're basically saying in that document, for the most part, is if I am not going to recover and if I can't make my own medical decisions, then I'm allowing my agent to call it, to say, we're not going to do this any longer. And you're empowering that person. You're giving them backup. So in addition to them having the authority under the healthcare proxy to act, you're giving them additional authority by making it very clear that they know your wishes and that they have the authority to remove these types of treatments. And that's a really helpful thing for, again, for your agent, and it's good backup for them. People can alter this document. It's obviously written in advance, we call them advance directives. It's written in advance of knowing most of the time what your ailment will be, how old you're going to be, what other ailments you might have, what treatments are available. And so it can't be written super specifically, but it's just a general statement of your wishes. Now, there's a different type of living will you can also sign that says the opposite. It says, regardless of whether or not I can improve or recover as per my doctor's recommendations, I would like to be kept alive under all artificial means necessary. And there are some clients that choose to sign documents like that. There's a third set of clients that often say, I don't want to sign the living will. I feel comfortable that I've signed the healthcare proxy. I've empowered my agent to make these decisions when the time comes, and I don't feel the need to sign this living will because it feels like I'm making too big of a decision right now. And some people choose not to do that, and that is certainly within someone's right. It can often be helpful to have a living will, even if you don't have a healthcare proxy, because whomever your substitute decision maker is, this is a direction to them as to what you would want. It could end up being a court-appointed guardian that's making those decisions, but that living will could guide them in those decisions, especially if they became your guardian and never were able to have a conversation with you. If you've lost your capacity already when they were appointed, they might not know what you would want in those cases. And for those who don't have any decision maker named, it can be direction to the doctors, to the hospitals, to whoever is making those decisions. So that's the healthcare proxy and the living will. Now, those have to do with you being incapacitated. So what about the situation where somebody just wants legal right over medical information? So take that college student that I was talking about. Maybe that college student, if they feel comfortable doing so, should sign a HIPAA release. HIPAA is the healthcare privacy law that we have. And if you sign a HIPAA release and submit it to a doctor, to the school's infirmary, whatever it may be, it can authorize another person, the parent in my example, to receive medical information regarding the individual. And that does not require any witnesses. It only requires that the student in my example sign it, and then it be submitted. And again, it can have a duration, so it can be limited in duration or it can be infinite. And that can just provide the information. That's not creating a decision maker in the person that can have the information released to them. It's just allowing information to be released. Because if you are still have your mental capacity, but you want someone else to get the information, that's what you would do. I've also used a HIPAA release in circumstances where there's multiple family members, say there's 3 children, and the parent might want all 3 of them to have access to medical information, but yet only one is the decision maker under the healthcare proxy. The HIPAA can be useful in that case. It can also be useful in the example that I gave of the child who was named as healthcare agent, but mom still has her capacity, and that agent can also be listed on the HIPAA release so they can receive information before they are the official decision maker under the healthcare proxy, because mom still has her mental capacity. So as you can see, all of these documents work together. You want to think about who you're naming under which document and what power you're giving to them and what direction you're giving to those individuals so they know what to do in your place if you can't make a decision. The last healthcare document I want to talk about is a MOLST form, MOLST, Medical Orders of Life-Sustaining Treatment. And this is a document that, unlike the others, is not signed just with the witnesses. It is signed with your physician. Remember, it's medical orders for life-sustaining treatment. And it's a medical order signed by a doctor, just like a DNR, a do not resuscitate order. That is also a medical order signed by a doctor at the request of the patient. The MOLST form is a great form for those who have a terminal illness or who are later in life believed to have less than 6 months to live. The MOLST form is a form that follows you from treatment center to treatment center if you are moving from, say, home to hospital to rehab to nursing home, back home, etc. And the MOLST form, in more specific detail, lists your wishes. So remember, the other ones are advanced directives that we've signed maybe 5, maybe 10, maybe more years before we're actually in a place where we can't make our own medical decisions. And so what the MOLST form does is we now have more information when we're signing the MOLST form. We're talking to our doctor. We know what our illness is. We have an idea of what the current treatments are. And an agent under a healthcare proxy can actually sign the MOLST form on behalf of the individual with the physician. It's a hot pink form issued by the Department of Health, and you can look at a sample of it online, but if you're filling out a MOLST form with the doctor, it should be done on the original Department of Health form that the doctor can provide. Medicare does pay for a visit to the doctor to complete this form. However, that visit is not a physical. It is just a meeting with the doctor to complete the form. And I have the form in front of me, and it talks about things that the other documents talk about. It talks about cardiopulmonary resuscitation. It asks if the individual has the other advanced directives. You know, does the individual have a healthcare proxy, a living will? Have they arranged for organ donation? That's an important one. Have you stated that you want to be an organ donor on your license or in your healthcare proxy document? And then it gives certain treatment guidelines. Does somebody only want to be kept comfortable? Do they want limited medical interventions, or do they want all medical interventions regardless of percentage of chance of a positive outcome? It talks about intubation. It talks about mechanical ventilation. About when somebody should be transferred or brought to the hospital, and in what circumstances they want to be left at home. It talks about fluids and nutrition. Should someone have a feeding tube? Should they be receiving IV fluids or no IV fluids? Or it actually has a box here for a trial period of IV fluids. And so it's a much more specific document. It talks about the use of antibiotics, when they should be used, when they shouldn't be used. And then interestingly, it has a section on the back where every time someone is transferred to a different facility or a different location, or any other time that the document is reviewed, there's actually a place where the date and time is reviewed. The physician who reviewed the document with the patient is listed and they sign. And then you either put that there's no change in the instructions, or that they voided the form and did a new form, or they voided the form and they didn't do a new form. So if that is a continual no change, no change, no change, those are the wishes that continue to stand. However, if somebody changes their mind and they have this review, then this can be voided through that method and then a new document signed. So the MOLST form is a really great tool, especially for those that are on home hospice. I had a client who did not have a healthcare proxy, did not have a living will, but she did sign a MOLST form with her visiting doctors. She was homebound and her doctors visited her at home. And when she eventually eventually passed away, she did so in accordance with the wishes as she stated them on her MOLST form. And it worked out perfectly because the home health aide that was with her knew what to do, along with the hospice care, the hospice service that she had called in to cover things. So having these documents in place, either the ones that we do in advance, the healthcare proxy, the living will, and the HIPAA release, or fast forward to later in life, the MOLST form, these are really important documents to make sure that your healthcare decisions are followed to the extent that you want them to be. Another document that I want to talk about that I don't count as an advanced directive, but is often lumped in with those in the planning stages is a power of attorney. So those other documents I talked about are all healthcare related, but now the power of attorney document is financial. It's the business of your life. And not all powers of attorney are created equal. Now, many people do sign the power of attorney with the idea being that it is an advanced directive. In their mind, it will only be utilized by the agent that they're naming if they should become incapacitated. But technically, unless the document states that it's not in effect when it's signed, the power of attorney is in effect when I sign it as what we call the principal. I'm creating the document. And when my agent signs it and has it notarized, then that agent can go forth and use the document to act on my behalf, regardless of whether if I have mental capacity or not. So and quite often that's how we recommend people do things, because we've had issues over the years where if a physician is listed as the physician that has to sign off on somebody's incapacity for the document to spring into effect, a springing power of attorney, what if we can't find the physician? What if we can't find any physician that's willing to certify as to somebody's financials because they don't want to get involved, not because they necessarily think someone does or doesn't have capacity, but because they don't see it as their role? Then we can end up in a circular argument where we don't have somebody who can certify that the power of attorney is in effect. And there's also gray areas of capacity. So there are obviously some people who have full capacity and some people have no capacity, but there's a lot of people that fall in that in between, and they might need assistance and they might want assistance, but they can still do things on their own. And so a power of attorney document, if it's not springing based on capacity, can actually be a big help if I feel comfortable doing things on my own, but I want someone else to be able to do it as well. I don't want to have to be deemed incapacitated if it's not necessary. I'm very happy to do some things on my own, but to pass off the things that are overwhelming or something I don't want to do. And so because of those gray areas of incapacity, I get nervous in a lot of circumstances, especially for older adults, to make it a springing power of attorney. A power of attorney is signed by two witnesses. One of them has to be a notary. So there's two witness places and there's a notary, and the notary can be one of those two witnesses. Now, our power of attorney law changed in June of 2021. So effective June 13th, 2021, we have a new power of attorney law and a new form that goes along with it. Now, the form only gets you, let's say, 60 or 70% of the way. There is the ability to add modifications to the form. Those modifications can include gifting. Now, gifting is a scary term for people, but when we talk about gifting in the context of a power of attorney, what we're talking about is the ability to move assets in and out of someone's name. That's not necessarily just a straight gift to a family member, a friend, a charity. It could also be a transfer to a trust for the benefit of the individual, and other transfers that become necessary in, for example, maybe the Medicaid planning context. So you want to make sure when you're signing a power of attorney document that you understand the powers that you're giving and that you're comfortable giving those powers, but also that you have all the powers that might be needed down the line that you didn't even realize might be needed. And so seeking an attorney's advice in creating, completing, signing a power of attorney is very important. If you have a power of attorney from before June 13th of 2021, you actually don't need it to be redone. However, it is grandfathered in as long as it was valid when you signed it, but you want to make sure that it does accomplish all the things you want it to accomplish. And so what we're telling a lot of our clients is if you have a power of attorney from before that date, you might want to have it reviewed to make sure that it still is going to accomplish what is needed down the line, especially if you do lose your capacity. Another big change in this law was that it allowed for a third party to physically sign the document on behalf of a principal who cannot physically do it. So I had a client who could not physically hold a pen because of her disability, and she could have a conversation with me. She could tell me who she wanted to name as agent. She understood the document. We reviewed it together. But when it came time to sign, she was there. I was there. I signed on her behalf. I had a witness, and I had a second witness who was also a notary. So it was properly witnessed and signed. And then I was the one who signed on her behalf. And I noted on the document that it was me signing on behalf of the client. And that is perfectly valid under this new law. And that's really great for those with physical disabilities who have the mental capacity to complete these documents and to state their wishes, but physically can't get it done. And so that is a really huge deal. And we're really excited about that change. Another change to this power of attorney law had to do with banks and other third parties unreasonably rejecting the document. You know, a lot of us have heard it's too old. In some cases, I've heard it's too new. And those are not reasonable reasons to reject a document. And so these institutions that are rejecting documents can now have their feet held to the fire to comply with this new law to make sure that those with valid powers of attorney have those documents honored. Because what's the point of signing these things in advance and doing the planning if when it comes time for your agent to act, they're being told that they don't have the authority for some reason that doesn't make any sense. And so having your power of attorney reviewed every once in a while is a good idea to make sure it's valid. There's no issues with it, but it is not going to be necessary to totally re-sign it every certain period of time. It's too old is not a real rule, and you don't have to worry about that. The last thing I want to mention, and then I'll go to questions, is we often get questions from people about if you live in 2 states or if you are permanently moving from one state to another. So we have a lot of clients, for example, who live in New York and live in Florida, and they truly split their time more or less 50-50. We will often tell them that you can have advanced directives in both states. Now, I wouldn't necessarily recommend naming different people in different states because then you have conflicting documents, but there's something to be said for the local authorities and the local institutions recognizing local documents and local forms. The reason that this can sometimes be helpful is because in case of an emergency, if you are in that other state and you can present your Florida healthcare proxy, they're going to see it, they're going to understand it. It's not going to be a foreign thing. Well, what does that mean under New York law? And they don't have to determine that. So some of our clients do choose to have documents in both states. Now, it's not necessary. Your document that you've signed in New York should work perfectly well in another state. But because these are governed by state law, you want to make sure that all of the information is going to translate from state to state and that there's not something additional needed in another state. With the power of attorney, we have such a comprehensive power of attorney and such a comprehensive power of attorney statute that generally I find if my clients go from New York to another state, that other state will think the New York power of attorney is great because it has all the powers listed and necessary. But when people often come into New York from a different state, I have the problem that their power of attorney from the other state doesn't have all the powers specifically listed out the way we would do here in New York. And that creates an issue here because the power of attorney is written in New York that you need any power listed. And so clients can run into issues if it's not as comprehensive of a document. So if you are living in 2 places, you might want to think about having more than one document and seek an attorney's advice on that in both states. Now, if you're permanently moving from one state to another, and you still have the mental capacity to do new estate planning, I always recommend that you check in with an elder law estate planning attorney in the new state to see if they recommend any changes. Now, this is not just to your advanced directives and your power of attorney, but potentially to your will or trust, depending on what other estate planning you've done. And so moving from state to state triggers that meeting with an attorney in the new state to determine what should be done, if anything, in terms of your estate planning documents. Well, thank you everyone for joining us today. Please stay cool in this weather and stay hydrated. And we look forward to seeing you at the next webinar that we do. Have a great day.